All right, it's now my pleasure to introduce our speaker, Alexander R. Cohn, a colleague of mine at the Atlas Society for the last 2 years, but for many years before that, someone who participated in our programs as student, scholarship student, advanced work in doing advanced work at our graduate seminar, and so now we have all of his time, or not quite all. Alexander is the managing editor of our Business Rights Center, working with Roger Donway and the rest of us who participate in that particular program. He's been writing he has written many blog items for the Business Rights Center blog, as well as major articles. He is one of the staff who is actively speaking not only at our conference, but at conferences by other groups, such as Students for Liberty. Alexander had earned a bachelor's degree in broadcast journalism at American University here in Washington. He has done graduate work in philosophy at the City University of New York and then the University of Virginia. And in between, he earned a law degree. So this is a man of many parts, and I'm very glad to introduce him for his discussion of antitrust. Thank you.
Bookstores used to look like this, Hollywood tells me. This is the store where Bastian Balthazar Bach steals the never-ending story. The proprietor, Mr. Coriander, tells him, "Here we just sell small rectangular objects. They're called books. They require a little effort on your part and make no beeps." I don't think I've ever seen a bookstore that looked quite like this. I think I've seen some that come close. But for a number of years now, both small independent bookshops such as Coriander's and chain bookstores have been losing business to Amazon.com, and with good reason. Unless you need a book immediately, Amazon is more convenient. Searching by typing in a title is faster than searching a shelf. When you find what you want, the book comes to you. Amazon has a wider selection than any brick-and-mortar store can feasibly offer. And Amazon can give you recommendations based on customer reviews and what customers who like the same books you do have bought. Add on Amazon's outstanding customer service, and it wouldn't be a surprise if the story of the brick-and-mortar bookstore is ending. Indeed, with Borders out of business and Barnes & Noble closing branches, it may well be ending. But the shift to ordering books online isn't the only revolution Amazon has brought to the book business. 6 years ago, Amazon introduced the Kindle ebook reader and began delivering its books electronically too. And in addition to its Kindle devices, which are now available in models from $69 to just over $500, Amazon has introduced a variety of software Kindle readers you can use for free. There's even a Kindle for Android, so you can get your books on a small rectangular object that makes a lot of beeps. The story of brick-and-mortar bookstores hasn't quite ended yet. Last calendar year, they produced more revenue for publishers than their online competitors did. But that gap is shrinking. That $6.9 billion represents a 21% year-to-year increase. The $7.5 billion represents a drop. And growth was almost entirely in electronic formats. Ebooks rose by a third. Sales of children's and young adult ebooks more than doubled. That's actually as a percentage of publishers' revenue, but those are the figures I've got. 2 years ago, Amazon began selling Kindle books faster than print books. Now, I expect these patterns to continue, but there are a couple of facts I want to mention that have changed. In 2010, before Apple entered the ebook industry, Amazon was selling 9 out of every 10 ebooks. and it sold many ebooks for $9.99, less than it was paying the publishers for them. Amazon was able to do that because the ebook business at that time operated on basically the same model as the print book business, what's known as the wholesale model. It's more or less the same thing you might see in any line of manufactured products. I make something, it's mine, I sell it to you, now it's yours, you can sell it for however much you please. Now, there are certain complications, particularly relating to returns, but that's the basic principle. The publisher sells it to the retailer, and then it's the retailer's property to dispose of at a price of his choosing. Now, ordinarily, of course, you might think that the retailer's goal is to maximize his net revenue on the sales of the books, and certainly not to lose money on the books. But of course, Amazon wasn't just selling books. It was selling Kindle devices. So it could afford to lose a little money on ebooks in order to motivate people to buy Kindle hardware. And it wasn't just selling Kindle devices. It was selling the ebook experience to people who were used to hardcovers and paperbacks. So Amazon had work to do to get people to make the transition. And it did that work in part with the $9.99 price point. At $9.99 an ebook, it might be half the price of a hardcover. Now, it's easy to see why all this might concern you if you happen to be in the bookstore business. But why should it worry the publishers? If you're making billions of dollars from ebooks, isn't that a good thing? Well, maybe not in the long run, because of one simple question. Who needs you? In olden times, a publisher did important things, like risk the money on printing many, many copies of books that might only sell a few. But that was when putting a book on the market required printing large numbers of copies, doing advertising, and other things that required significant investments of money. And that was when space on bookstore shelves was very scarce, and it took publishers' networks and relationships to get it. In the ebook world, it takes virtually no investment beyond the time of the author and perhaps an editor or illustrator to put a book on the market. I myself did a lot of the work of turning Roger Donway's book, Rich Hunt, from a Word file into a finished product. Because of technical problems, I did end up having to use a commercial service to help prepare the ebook version. And it did cost the Atlas Society a fairly small amount of money. But once that was done, listing the ebook on Amazon was free. It was free because the marginal cost to Amazon of adding an ebook to its database is virtually nil. And that means that anyone who isn't so controversial that Amazon doesn't want to touch him can sell his book on Amazon. He doesn't have to convince Amazon that he's got a particularly good book. Print on demand makes selling print books almost as simple. You can buy Rich Hunt in paperback on Amazon. It doesn't have a major publisher behind it, just the Atlas Society. But because Lulu does the printing on an on-demand basis, we didn't have to invest thousands of dollars in copies to sit on shelves awaiting purchasers. And you can have it shipped to you overnight by Amazon, just as easily as you can have the Hunger Games shipped to you overnight by Amazon. There is no difference between your experience going and ordering Rich Hunt and going and ordering the Hunger Games. Try that with brick and mortar. So far, even when it comes to purchases of ebooks from Amazon, the books sold by the 6 major publishers are doing much better than books by independent authors. But independent authors can now make a living selling their books directly. I know at least one who is. Now, I enjoy reading independent books. I've been involved with several of them, both inside and outside TAS. And I have a couple of book projects of my own on the back burner. So I am really hopeful that the publishers as we know them will go the way of Borders, and the work of connecting authors to readers and getting money from readers to authors will be done by Amazon and other companies in the high-tech retail business, such as Apple. Now, you might think I'm being a bit too techno-optimistic. Possibly that's the case. But according to the federal government, the publishers thought something similar, if a little less revolutionary, might happen. That if Amazon, by means of that $9.99 price, became a big enough hub for ebook buying, Amazon would begin buying books directly from authors. That it would become a publisher in its own right, in effect. Of course, for the publishers, the prospect of authors dealing directly with Amazon was something to fear, not something to celebrate. The publishers feared something else, too. They were concerned that if people got used to buying ebooks for $9.99, they'd come to think that that was all a book was worth, even in hardcover form. And that would threaten their ability to sell their most valuable products. Plus, the publishers feared that the more of the market Amazon controlled, the more Amazon would be able to negotiate lower wholesale prices. For all these reasons, at least on the government's account, the publishers were afraid of Amazon. And if you're wondering at this point why the federal government has an account of this, well, that's why this story is beginning an antitrust lecture. It was antitrust law that pinned the publishers. Here's the problem that they were facing. And to be clear, I'm following the government here, but I have a reason for that. Their industry was in jeopardy because of what Amazon was doing. They were threatened by the rise of ebooks, and they were especially threatened by Amazon's market share and that $9.99 price. But the books, both print and electronic, that the public wanted were the books that the publishers controlled. If the publishers stopped doing business with Amazon, Amazon would effectively be out of the book business. So if the publishers all made the same demand and held firm on it, Amazon would have to yield. But Amazon would not have to yield if only one publisher stood up to it. It at least seemed that Amazon was in a position to cut off any one publisher. There were 6 major ones. And at one point, when one publisher went to Amazon with a demand for higher retail prices, Amazon did indeed stop selling that publisher's books, both print and electronic. And the publishers were afraid of just such retaliation. Remember, Amazon was already a major book dealer, both print and electronic. It would not be easy to give up that business. In order to confront Amazon, the publishers needed unity. But the situation wasn't so urgent that all the publishers had to act right away. So they couldn't just count on one another to confront Amazon simultaneously, spontaneously. Not unless they deliberately chose to come together and coordinate their approach. And that is where antitrust comes in. Under the antitrust laws, that would be a conspiracy. You're not allowed to unite with your competitors to negotiate for higher prices. So the publishers were stuck. If they kept doing what they were doing, they would strengthen Amazon and endanger their own businesses in the long run. If they stood up to Amazon individually, they risked retaliation in the short run. And if they organized and negotiated with Amazon as a group, they risked a federal lawsuit. Now you might ask, a conspiracy to do what? Normally you say conspiracy, that's conspiracy to do something that's illegal anyway. And surely it isn't illegal to refuse to sell books. So how can you have a conspiracy to refuse to sell books? Well, even under antitrust law, it usually is legal to refuse to sell someone your product. But ever since the Sherman Act of 1890, antitrust law has prohibited something called a conspiracy in restraint of trade. To make a joint effort a conspiracy under antitrust law doesn't require that what you're agreeing to do be illegal on its own. Quite the contrary. Often the acts you agreed to do to raise legal issues only because you agree to do them instead of doing them independently. If the publishers had all spontaneously decided that the time had come to stand up to Amazon and negotiate for a higher retail price, that would have been perfectly legal. If any one publisher had acted on its own, that too would have been perfectly legal, although it would have risked trouble with Amazon. It's the organizing that's illegal. In late 2009, while the publishers were in that predicament, Apple Computer was preparing to launch the iPad. And Apple decided it wanted to go into the ebook business in competition with Amazon. Originally, it intended to use the same wholesale model as Amazon. But according to the government, two publishers offered an alternative, and Apple revised and adopted it. Under the agency model, the publishers would set their own retail prices subject to certain limits. Apple would stick to that price and keep a percentage. So if a publisher decided that the price of a certain ebook would be $12.99, the cap for many books, then that would be the price. Apple wouldn't stick them with the $9.99. Except, of course, for one thing. Just because Apple was selling an ebook for $12.99 didn't mean Amazon would sell it for that price. And as a journalist pointed out to Steve Jobs when he revealed the iBookstore, if Apple is charging $3 more for ebooks than Amazon, why would any customer buy the ebooks from Apple? Well, Steve Jobs knew that one way or another, Apple wouldn't be charging $3 more than Amazon. Apple's contracts with the publishers provided that if any other ebook store charged a lower price, Apple could match it. And Apple would still get its 30% commission. This is what's called the most favored nation clause. From Apple's perspective, of course, that means Apple doesn't have to worry about being underbid, and it can still make money on each book. But if we consider things from the publisher's perspective, and the government says Apple knew exactly how this would work from the publisher's perspective, this has a much bigger effect. Consider a fairly typical book that Amazon is selling for $9.99 with a 1-cent loss. The publisher sets a price over with Apple of $12.99. Apple enforces the MFN clause and uses the $9.99 price. Apple still gets its 30% commission, which of course is a bit smaller now, but still $3. The publisher gets $6.99. And suddenly the publisher isn't just looking at a long-range threat. And with that short-range threat, it now has no choice but to confront Amazon, and neither do the other publishers. Now, they all have the urgency they need, and they all know that their rivals have the urgency they need to go and confront Amazon immediately and stick to their guns. When the first publisher went to Amazon and demanded to switch to agency, Amazon briefly stopped selling its books, but only briefly. After a few days, the books were back on sale, and the publishers had won. That's some fight. So who's the good guy here? On the left, Steve Jobs, the late co-founder and CEO of Apple Computer. On the right, Jeff Bezos, founder and CEO of Amazon.com. Well, of course, the first thing to say is they're both brilliant businessmen, huge producers of value, heroic innovators. From what I know of them, these are both admirable people. That said, as a customer, I'm a lot happier with Jeff Bezos. And that's not just because I've had very positive experiences with his company as a customer. In this particular context, it's because I'd rather pay less for ebooks than more. And it's because I think the radical changes in the book industry that Amazon is bringing about, that the publishers were so afraid of, are to the good for both readers and writers. I think the demise of the publishers, at least in terms of trade books, would be no big loss to readers and writers. But even if I'm right that the agency model made things worse for readers and writers, the publishers thought that it was what they needed, and on the premise that it was in their interests to stay in business, which it seems like it's usually a good premise to assume that it's good, it's in people's interest to try to stay in business. It may have been the best they can do. Now, it may well be that given the present state of technology, the rational thing for a publisher to do is to find a new endeavor. And maybe in the long run, the publishers will have to do just that. But the publishers, like the rest of us, are entitled to live and work for their own sake. The people who own and run the publishing companies ought to fight for their business so long as they think it's rational to do so. Morally speaking, they don't owe it to readers and writers to do business in a way that leads to going out of business, even if readers and writers would be better off without them. Amazon may have been making our lives better, but to the publishers it was a threat. And Apple gave them the strength to fight back, at least until independent books became popular enough to put the publishers out of business anyway. But the Federal Department of Justice determined that giving the publishers the strength of unity made Apple the ringleader of a conspiracy. According to the government, what Apple knew that the publishers knew, what Apple made sure that the publishers knew, that they were all coming on board with this, was enough to create a conspiracy in restraint of trade. But what does this mean, conspiracy and restraint of trade? How can business deals be a restraint of trade? They are trade. Or if they're restraints on trade just because they bind the parties to particular courses of action, then aren't all contracts restraints of trade? For that matter, what is monopolizing, which is also prohibited by the antitrust statutes? These are obvious questions, but the way antitrust works, they're not actually the key ones. Indeed, if you want to understand antitrust law, there could hardly be a worse place for you to start than the antitrust statutes. Antitrust law, while nominally based on various acts of Congress, is primarily a body of precedent developed in the federal courts over the century and change since the Sherman Act. Congress hasn't so much created it as chartered the courts to create it, and occasionally revised or strengthened it. The essence of antitrust law is its distinction between competitive and anti-competitive behavior. This distinction operates pretty much the same way no matter what statutory provision is involved. Not all anti-competitive behavior is illegal. As we'll see, there are remarkable exceptions. And sometimes an anti-competitive course of action falls through the cracks between the statutory provisions. But conspiracy and restraint of trade is basically any anti-competitive agreement. Monopolizing is basically trying to gain or keep a monopoly by anti-competitive means. To understand the moral issues in antitrust, and for that matter, to understand how to avoid violating antitrust law, the place to focus is the competitive anti-competitive distinction. Now, I have to say, before I began learning antitrust law, I was utterly mystified by this term anti-competitive. How can doing business be anti-competitive? Surely, if you're trying to squeeze your competitor out of the market, what you're doing is competing. It makes sense, doesn't it? Modern antitrust law has been heavily influenced by Robert Bork, so let me share his definition of competition. Competition, for purposes of antitrust analysis, must be understood as a term of art signifying any state of affairs in which consumer welfare cannot be increased by judicial decree. So if a court, by stopping businessmen from doing something, could make consumers better off, then competition does not exist in that market. Now, the issue is not the well-being of any individual consumer. If I happen to want a particular product and that product goes off the market, that is not the concern of antitrust law. What the courts are looking at is aggregate economic welfare and especially consumer welfare. And if I am vague on this point, it may be simply because I am not an economist. And it may also be because most judges who are defining all of this aren't economists either. They, like me, are lawyers. So usually, the courts deal with things in a way suitable to lawyers. And the question is the business behavior at issue competitive, or sometimes called pro-competitive, or anti-competitive? Now, it would be silly to expect businessmen to focus on creating a state of affairs where consumer welfare can't be improved by judicial decree, and antitrust doesn't expect them to think in those terms. What antitrust does expect from businessmen is that they will, quote, compete on the merits, that is, on the price and quality of their products. And it's reasonable to expect that if you're competing on the merits, you're contributing to the state of affairs called competition, because you're trying to produce the best goods and services at the lowest price for your customers so that they'll buy your products. Now, I haven't found a formula from a court to define this question, so I formulated it myself on the basis of the cases. The central question is, are you trying to make a profit by means of how well you serve customers, that is, competitively, or by means of denying your customers better options, that is, anti-competitively? Now, the words by means of are critical here, because if you don't serve your customers to some extent, you're not going to succeed no matter what you do to your competitors. Even if I succeed in putting all the other pizzerias in town out of business, if I try to sell a slice for $100, I'm not going to sell any pizza. And on the other hand, I can be perfectly competitive and drive all the other companies in my field out of business simply because I'm serving the customers so well. And if I do that, that's still competitive, and competition still exists in the antitrust sense, even when I have a monopoly, so long as I gained that monopoly and kept that monopoly just by providing a good product or service at a good price that nobody else could come in and beat. Perhaps the best illustration is the difference between competitive and predatory pricing. So suppose Lucia is selling pizza $3 a slice. Sal comes in and starts selling pizza $2.50 a slice. Sal's pizza is not as good, but it's cheaper. And suppose that so many customers move over to Sal that Lucia is now failing to cover her overhead. Now suppose that Lucia can profit at $2.50. She was able to get away with $3 when she was a monopoly, but okay, now she's selling for $2.50. Now what we have is competition on price. Now, when Lucia had a monopoly, that was fine because she hadn't done anything anti-competitive to get it. And she goes down to $2.50 a slice. Still fine. Now she's competing on price. Customer is better off. Now he's getting Lucia's pizza at $2.50 a slice. And even if by selling pizza at $2.50 a slice, Lucia puts Sal out of business, it's still okay under antitrust law because Sal going out of business is an effect, but not the means of Lucia's profit. Lucia would be making a profit at $2.50 a slice if she sold enough slices, whether Sal stays in business or not. But now suppose that Lucia lowers her price to $2, even though she can't make a profit at that price. Her ingredients and her other costs are so expensive that no matter how many slices she sells, there's no way she's going to make a profit at $2 a slice. But Lucia's been a monopolist for years. She's got money put away, and she knows that she's not going to have to sell pizza for $2 a slice forever, because nobody's going to buy Sal's crummy pizza for $2.50 when they can get hers for $2. She knows Sal's going out of business. She's counting on it. Sal goes out of business. Lucia raises her price. The predatory move made the customer worse off because Sal is now gone, and the customer would have preferred to go to Sal. And what Lucia has done is anti-competitive, because the $2 slice did not make sense for Lucia except on the condition that it put Sal out of business. It took away the option of going and buying pizza from Sal, and thereby allowed Lucia to raise her price again. Lucia makes a profit in the long run by lowering her price to $2 only by means of putting Sal out of business. That is predatory pricing, that is anti-competitive behavior, and that is illegal under the antitrust laws. And notice, by the way, that if there is no price such that Lucia can make a profit even while Sal is in business, compete that way, Lucia still is not allowed to go down to the predatory price. Lucia has to be the one to go out of business under the antitrust laws. So let me give you some real-life examples. In the 1970s, the 4 ski areas in Aspen, Colorado were owned by 2 companies. Ski Company owned 3, Highland owned 1. They put together a joint package, and then Ski Company decided to get out of the joint package. In fact, Ski Company refused to sell Highland's ski tickets even at full retail price. Apparently, Ski Company thought that since it was able to offer so much variety on its own, it would stop giving Highlands the benefit of that variety. If you wanted a variety ticket, you'd have to buy it from Ski Company, and it would only cover Ski Company. Highlands sued, and in 1985, the Supreme Court found that when Ski Company refused to provide the benefit of the variety that only it could offer to its competitor, that was anti-competitive. In antitrust terms, that makes sense. Ski Company was trying to get more buyers for its single company variety tickets by taking away the option of the joint package. Superior Court Trial Lawyers Association is actually a case about business owners going on strike. The trial lawyers, in this case, are the business owners. They're attorneys in private practice who often accepted appointment as criminal defense lawyers for poor defendants. They were paid at a rate fixed by the organization that paid them, the D.C. government, and they didn't like the rate. So they demanded a higher rate and quit taking cases. They got their higher rate, and then they got sued by the Federal Trade Commission. The Supreme Court said their joint action was a conspiracy to fix prices. That is to say, a form of conspiracy in restraint of trade, illegal under antitrust law. The way a strike works is by denying the employer, who is the worker's customer, other options. In the trial lawyer's case, if any one lawyer had demanded the increased rate, the court would not have paid. It would just have gone with another option, that is to say, another lawyer. So it would not have been in any one lawyer's interest to stop working and demand an increase. But suppose that all of us here are lawyers who've been taking these cases. If I make the demand alone, David and Brandon get more cases, and I get none. And the rate stays put. But if we operate as a team, then by refusing to take cases, David and Brandon make sure that the court can't replace me, and I make sure that the court can't replace them. If I organize such a strike or even participate in it, I am seeking higher pay by means of denying the court the other options. Now, that's true whether we're operating as workers or a union, in a union or business people in a trade association, but Congress has specifically exempted labor unions from the antitrust laws. When such an agreement is covered by the antitrust laws, it's called price fixing. And it applies, of course, to the sale of goods as well as services. For example, there were executives of major manufacturers of LCD screens not long ago criminally convicted of fixing prices. And we see that basically something very similar was going on with the publishers, or would have been going on at least, if they had operated without Apple's help. And to the extent that the Apple arrangement actually amounts to an agreement among the publishers, it looks anti-competitive too. Indeed, Apple appears to have been acting anti-competitively simply in that it was seeking to make a higher margin on its ebooks than it otherwise might have by means of stopping its competitor from charging a lower price. However, that particular anti-competitive move might have slipped through the cracks in the statutes if the publishers if what the publishers did doesn't amount to an agreement. So, what's the problem with antitrust? Well, first of all, obviously it violates rights. Anti-competitive behavior isn't normally violent or fraudulent or even in breach of contract. Among the features that distinguish antitrust law from most other branches of economic regulation that share those characteristics, though, is that antitrust governs all branches of production and trade except those from which it is specifically excluded. Now, if we understand the intrusiveness of a regulation by how often it makes you do something other than what you'd do without it, antitrust probably isn't very intrusive. Probably most of the time, if you're a productive business person, you do the same thing with antitrust law there that you would have done without it. And yet, in a sense, antitrust is relevant to every single transaction, because you can always ask whether a businessman is doing something competitive or anti-competitive. By warning businessmen not to pursue anti-competitive measures, antitrust law demands that businessmen always pursue competitive measures, that they strive to succeed through serving their customers better than their rivals can. Of course, ordinarily in a free society, that is how you go out and produce. But antitrust says, in the rare cases where there's a conflict, you must serve your customers instead of yourself. Your customers and not yourself are your priority. Thus, antitrust rejects, insofar as production and trade are concerned, the principle that every person is an end in himself, that his own life is the proper goal of his actions. Granted, antitrust does not demand that businessmen explicitly reject the principle. It isn't concerned with motives. But under antitrust law, it's the producer's service to the consumer that justifies his actions. And herein lies antitrust's essential evil. It demands that the individual be prepared to justify the pursuit of his own interests by appeal to the benefits he provides to others or to society. It says the scope of your freedom and your claim to freedom are not based on what you need in order to survive, flourish, and be happy, but on how your being free helps other people. Stating it that way doesn't even quite cover it, though. To see what antitrust says about the role of government in our lives, let's take a quick look at a couple of exceptions to antitrust. The federal government, of course, can make exceptions to antitrust whenever it wants. It's a federal law. The federal government can change it. But what's unusual is that the states get to override antitrust in the pursuit of their own projects. Ordinarily, states don't get to override federal law. So, for example, if a state decides that its alcohol regulator is going to be the only liquor seller in the state, that does not violate antitrust law. And, of course, under the First Amendment, we have the right to petition the government. But given that the government, both federal and state, can cut holes in antitrust law, that has remarkable consequences. It creates what I call the cronyist exception to antitrust law. Consider, I may not try to put my rival out of business through predatory pricing, which is simply a matter of how I'm offering my products. But I have every right to try to put my rival out of business by going to the legislature and asking that he be banned. And I may not agree legally with all my competitors on the fees we're going to charge. But I can go to the legislature and ask the legislature to impose a fee schedule. Ayn Rand asked, by what conceivable standard can the policy of price fixing be a crime when practiced by businessmen, but a public benefit when practiced by the government? If price fixing is harmful to competition, to industry, to production, to consumers, to the whole economy, and to the public interest, how can that same harmful policy become beneficial in the hands of government? She was right to ask, and while it turns out there's an answer, it's an answer worse than there not being an answer. The answer is that government, that with or without a government mandate, price fixing and these other anti-competitive behaviors do inhibit competition in the antitrust sense and do deny consumers the benefits of competition. But the benefits of competition, such as low prices for goods and services, are only some of the values that government pursues. On the premise that human activity ought to be organized by government for the public good, a decision by government to mandate price fixing or permit it in a particular context is a trade-off. Government gives up the benefits of competition and in exchange gets the benefits of price fixing, such as the preservation of existing manufacturers or a guarantee of profits that may encourage additional investment. But when private parties engage in price fixing, they arrogate to themselves the power to make trade-offs that on this view are the prerogative of government. That is to say, they deprive government of the power to fix the goals of their actions, and they seize the power to set the purpose of their own life for themselves. So to summarize, these are the principles of antitrust. It's the government's prerogative to set the goals of economic life. When the government hasn't prioritized something else, the goal is consumer welfare. Competition is how you maximize consumer welfare, and this is meant in two different senses of competition. The state of competition envisioned by antitrust law simply is a state where consumer welfare is maximized so far as judges can do anything about it. And if businessmen engage in competitive behavior, they'll maximize consumer welfare because only through serving their customers will they make money. And for this reason, government must be free. Businessmen must be free. Their freedom is a franchise given to them by government in order to achieve consumer welfare. Government recognizes that businessmen, aided by market prices and restrained by antitrust law, can do a better job of producing the goods and services consumers want than government can directly. They can do a better job of figuring out what customers want, and they can do a better job of assembling the resources to produce it at a low price. But they need to be kept to the task by government. And that's what I mean when I say that under antitrust, businessmen are decentralized planners. Antitrust starts from the same moral premises as central planning, that government must set the goals of economic life and that meeting consumers' needs and wants is an important goal. But it recognizes that this goal is best achieved if economic power is decentralized, if decisions about the allocation of resources are made by business people. So it takes power that ultimately belongs to the government according to these principles and decentralizes it and delegates it to businessmen. Now, to many people, including people who lean libertarian, this may seem appealing. So I want to wrap up by reminding us what the fundamental moral principle of free enterprise is and how it conflicts with this. Your life belongs to you, and the good is to live it. This is a foundational principle of objectivist ethics in politics. It is the principle of fundamental moral liberation. You are the goal of your own life, and you are free to shape that life according to your own vision and for your own purpose. And that isn't just about your social life or your artistic life or your life as a consumer, it's about your productive life. When you go out and work, whether as a business person or anything else, you need to do it for your own good. And you need to recognize that you do it for your own good. When you make something, when you sell it, and for that matter, when you buy something, you need to focus on the contribution it will make to your life. When antitrust says that the purpose of your productive life is to serve others and not yourself. It is saying that your good isn't good enough, that your life isn't good enough to be your goal. Free enterprise, properly understood, is an economic system based on your right to the pursuit of your own happiness. Antitrust, no matter how much or how little it changes the decisions that you actually make, denies that businessmen have the right to pursue their own happiness when it says that the goal of their efforts must be the goal that the government assigned them, the welfare of others. That is the moral significance of antitrust law, and that is its essential evil. Thank you.
I have a lot of conversation with friends about monopolies because the word is, equivalent to satanic in most people's minds. And I wanted to test out an idea and get maybe your objectivist response to the issue of predatory pricing, because it seems to me that if you don't have sort of the unnatural influence of pull or regulation, then the only way to get a monopoly through predatory pricing would be, it doesn't seem a problem to me, because eventually the sort of barrier to entry would be such that the monopoly's price, should they then raise it after they cut out all their competition, then they want to harangue everyone and get all their money by upping the price 500%. Eventually it'll be profitable for a competitor to come in, and assuming there's no regulation barring that, the monopoly won't last very long. And as an objectivist, I don't see any problem with that as far as pushing the price back up and using predatory pricing to eliminate competition if there's still a free market into which competition can always enter if the market allows. Is that correct?
Well, morally, the legitimacy of predatory pricing is not contingent on whether other people can enter the field. Now, you might get into a complicated issue there if the reason that people are excluded from the field is regulatory. But not all barriers to entry are regulatory. Sometimes, entry is very expensive because there are limited natural resources that you need, because there are intellectual property issues, because there are brand recognition issues. Moreover, if the costs of entering the market are reasonably significant, and you look like you're prepared to do it again, then you can deter potential entrants basically by saying, look, I am making enough money that if you come in, unless you have a lot of money behind you, I am going to predatory price you right out of this business. And you're going to end up having lost everything that you invested in getting in. Now, is that being a heroic business person? I wouldn't say that. But is that being a rights violator? Definitely not. Is that, and if, and actually, in some contexts, it might be being a heroic business person. Remember my example of Lucia's Pizzeria, where Lucia is making very high quality pizza. This is her vision, to make the best pizza in the world. And it turns out that she can't actually sustain that model if there's a cheaper pizzeria too close by. But she can't afford to charge enough when there isn't one to make sure she's got enough money in the bank to lower her prices temporarily when one comes along. Jason?
Alexander, excellent talk. I'm curious. So, with your I guess studying of antitrust law, do you have a sense of whether antitrust law in general has gotten better over the last few decades? That whether it used to be worse than it currently is? Part of why I ask is that I know that you cited Robert Bork, and I know that he's often cited as somebody who I guess introduced a lot of I guess like changes to the way people thought of antitrust law to make it, I guess, a little more rational. But you know, I'm not myself especially informed on this, and I'm wondering if this is an opinion you share. What is your sense, I guess, of how antitrust law has evolved over the last few decades, and whether Bork has improved things or made them worse?
I think, first of all, my general impression is that things have changed in the direction of what I call, or what you might call objectivity in the sense of legal understandability, in the sense of the law having a determinate meaning, not in the sense of the law being justified, but in the sense of it having a determinate meaning, that it's possible to obey the law if you want to. It does seem to have moved in that direction. It does seem to have taken on this distinctive flavor from Bork. That said, Bork is not a radical departure from what came before. This is a case of what is, in practice, basically common law evolving under the guidance of a brilliant scholar. And that said, I have not really studied the history very much, which is why when I do the critique of Rand, when I do the response to Rand's critique, I don't say Rand was wrong. I just say, if you say this today, you'll be wrong. Because I really don't have, I haven't focused on what the law was in 1961 or at any particular time other than the present. Because I really think that's what's most relevant to be concerned with.
I had a follow-up to my, do we have time? So I was thinking about, I have a better way of explaining my problem. As an individual, self-interested business owner, I'm of the mindset, I don't owe anybody anything. And I think that's appropriate and consistent with the objective principles.
Indeed.
And so, but I want to get as much as I can because I have interests and things I want to do with my life. However, I can't do that by violating my principles. So, okay, so far so good. The problem is you have the examples of Hank Rearden and Dagny Taggart and Atlas Shrugged, who also provide amazing value. And when Dagny says, I'm going to fleece you for everything, Hank, and Hank's like, oh, okay. Everyone is okay with that because they're both providing amazing value. Everyone's going to profit. It's going to be great. However, you have basically the same situation tentatively, and that's just what I want to clarify. With predatory pricing, you've got a guy saying, because Dagny says to the Phoenix Durango, I'm going to drive you out of business if I can. She's saying but then again, I guess she's not really, not attempting to use predatory pricing, she's attempting to.
She never says one way or the other.
Well, she says she'll try if she can.
She says she'll try to drive him out of business.
Yeah.
Well, she would have tried to drive him out of business. But she would have tried to drive him out of business. She could have done that with or without predatory pricing. Right. Remember, if she can provide better service at a lower price and make a profit at the same time, that's not predatory. If she provides better service at a lower price by temporarily taking a loss that she expects to make back after the Phoenix Durango goes out of business and she raises her prices, that's predatory pricing. By the way, I have a hard time thinking of a single case of a Randian hero doing something anti-competitive. I can easily think of a Randian villain doing something anti-competitive, namely James Taggart putting the Phoenix Durango out of business by means of an agreement among competitors not to compete.
Right. So is predatory pricing unethical? I guess is my whole question the whole time.
I do not think that it is, particularly in the case where it is part of a model that can be sustained in the long run, such as Lucia's Pizzeria in my hypothetical. Now, I actually have my doubts about the publishers, which of course was not a predatory pricing case. It was quite the opposite. They were raising their prices, or trying to raise their price at retail, because I'm not sure it's rational for the publishers to try to preserve their current line of business in the face of technological developments. But if what Lucia is trying to do is create the world's best pizza, then, and there's enough of a market to sustain the world's best pizza in that location, provided that she runs a discount special anytime somebody opens up a cheaper pizzeria nearby. I'm not seeing the moral problem here. Now, if somebody else wants to put forward a moral argument against that, I'm open to it, but I haven't figured that one out yet, that there would be anything wrong with predatory pricing in a context like that. And bear in mind, predatory pricing only works if the maximum amount that your product is worth or your service is worth to your customers is sufficient to sustain not just a price sufficient to make a profit, but a price sufficient to recoup your loss on the predatory pricing scheme. So it's a question of how the gains from trade are divided between you and the customers. If your product isn't worth what you'd have to sell it for, if they would move to some completely different product, if it were the case that if Lucia, in order to make the predatory pricing worthwhile, would have to start selling pizza at $10 a slice, and everybody would start getting hamburgers instead, then predatory pricing doesn't work.
It only works if people keep buying your product.
That's right.
Which you don't owe anybody.
Indeed.